All right. I saw the chat earlier, so I guess today it's vanilla, Eric.
It looks like it.
Yep, it looks like it. We never know. All right.
Hey, what's up, peeps? Happy birthday, SteveGosney.com.
Thank you.
29.
Oh, happy birthday.
Ian, other Steve, Eric, hi.
Hey, hey,
How you
hey.
doing?
Great to
Pretty
see
darn
everybody.
good. Chandler should be here in an instant. We just wrapped up my stream.
I saw the Vices raid, and thank you very much. Good to see folks coming over here. But that's cool. We're going to start off, I think, with Steve, Southern Law. And I think all of you probably have been following this, but Murtaugh, what's going on?
Oh, my God.
Well, there could be some flaw in the normally flawless performance of the South Carolina judicial system. There's a disturbance in the force down there. And of course, people have been critical of this Murtaugh case for a while in terms of how he was indicted and whether SLED lied and lots of things like that. And the opinion on whether the jury got the right verdict or not is, of course, not universal. But he's back in the news because not for his tablet PIN number, but because his attorneys are filing papers with the Court of Appeals asking his appeal to be suspended so that he can move for a new trial based on this later discovered evidence, which is allegedly that the clerk of court was discussing the case with the jurors and trying to influence them. And I think the biggest allegation they make there is that the clerk said, hey, don't be fooled by the defense. Don't listen to Murdaugh when he gets on the stand, that kind of thing. You know, he's shifty, or, you know, not exactly those words, but that kind of context. And they have affidavits from 2 jurors, and then they have an affidavit from their paralegal who spoke to some jurors. So now we're at triple hearsay in terms of what the clerk said. But at any rate, some of them do say that she said, you know, don't pay attention to the defense when they talk. And that's a big deal. That is a big deal. You can't have that happening. If it did happen, and other things too, that she rushed them, told them it shouldn't take them long, they can't smoke, and blah, 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 and all of that. Not all of it's material necessarily, but it builds a picture that they're trying to paint. But when I read their papers, because the state hasn't responded yet, at least that I saw, I also saw they included an in-camera transcript where one of the two jurors who's filing an affidavit here was asked directly by the judge at one point during this thing about Facebook, did the clerk ever speak with you or anybody on the jury about this case, matters in this case? And this juror said, not that I'm aware of. And that occurred after Murdaugh's testimony had occurred, so the statements about don't pay attention to him should have occurred. That seems to be a contradiction, right? So this whole thing is going to be messy. Now, the clerk has said in interviews she's given to other channels, I never talked to the jury about anything about the case. She was saying that when she was pimping her book. And so she's going to deny it. And I don't know what the truth is. The situation is, has Murdaugh's attorneys presented enough information that warrants a judge looking at this? And while I do think he did it, I also think they have done that. I'm not saying that this occurred, but they have an affidavit from 2 jurors. I think that's enough that this ought to be explored, in my opinion. And the whole thing with the clerk is seedy. She had a document to the people doing a documentary down there, a contract where she added an addendum on her letterhead as clerk of court saying, if you use my likeness, you have to use a 5-second video of me. You have to show the cover of my book, and you have to show the introduction to my book. And you're not supposed to be doing that. And the clerk of court shouldn't be writing books about an actual trial and what went on behind the scenes and monetizing that position. So that's trouble too. But it's just generally speaking a disaster down there in South Carolina. I think whichever side you're on, there's no way to say the state is clean on this that I can see. It just looks like a big mess, and they have some work down there to do. And if I were to call it, I'd say there's going to be an evidentiary hearing. And if pretty much any of these things are established, they're going to throw the verdict out, because the case that the defense cites, State versus Cameron, the bailiff answered a jury question about what a sentence could be, saying, I'll go ask the judge and see if I can get an answer. But listen, this is a really fair judge, okay? And the Court of Appeals said there the bailiff should not have commented on the judge and threw the verdict out. So if you'll throw the verdict out for that, you'll throw the verdict out for the clerk saying don't pay attention to this and that kind of stuff. So it's a big mess.
I wanted to ask you about that because I was confused. I was telling my wife. So the clerk interacts with the jury in South Carolina, or what? Because I'm used to a bailiff being the one who takes them back, talks to them, and interacts
There's
with
a
them.
difference that needs to be made between like the court clerk and the clerk of court. The court clerk, she's the one that just types everything, types the transcript. The clerk of court is an elected governmental position where she's kind of the wrangler. She's the one that gets them their meals, gets them their transportation, gets them from point A to point B without getting lost. She's the one that interacts with them on a legally interacts with them. Like, what do you want for lunch? What's up for dinner? And how y'all doing? Do we need to turn the air conditioner on? That kind of stuff. But she takes it the step further, which is part of the problem, because she's speaking. And are they thinking she is speaking just as herself, or is she the representative of the judge in their mind? And I think when you're looking at this, as Steve was saying a minute ago, that you have if any one of these things, not the whole thing, you don't have to prove everything they said in their affidavit. If even one of these things is proven, I think you have to throw this verdict out and have a new trial, because as I've said from the beginning, and as Steve mentioned, it doesn't matter if he did this or not. Did they convict him fairly? And you're talking about a government that I repeatedly say literally has the power to kill you. They have the power to constructively kill you by throwing you in jail for the rest of your life. And they have the literal power to strap you to a table and inject poisonous fluids into your body and end your life. If they do that, they have to do this fairly and justly every single step of the way, because if you give them 1 inch of the way, they're going to take a meter. And the next time that Eric or Gosney or Ian Runkle, well, Ian's in Canada, but if he was in America, Ian, Chandler,
Steve, the US.
or I or anyone else finds ourselves in the situation, they can go, well, we didn't have that same burden of proof with Murdoch, so why do we have to do it here? You have to hold them to the highest standard of performance, ethics, morality, etc., across the board.
That chat, I think, is dead on, too. A member of the jury, I don't think they're unreasonable in believing that the clerk is conveying the voice of the court.
Well, I don't think that really you can come to another conclusion on that. That's going to be the default assumption when you've got the clerk saying something like, you can't smoke. Why would anybody assume that was, oh, this is the clerk's personal feelings, as opposed to like, this is a communication from the judge, or,
Policy,
any of these things.
Or law, yeah.
Yeah, well, now you should watch out, this guy's, even if you just take it as the clerk of the court, it still has more weight, because it's this person who, has obviously seen dozens and dozens of trials now, saying, oh, watch out for Murdoch now before he testifies, watch him real closely. And they take that to mean he's lying. It's like, oh, this person who's a court expert thinks he's lying. There's a reason. Like, if I, as a lawyer, walked back into the jury room and said anything like that, this next witness is a real liar, they would throw out the verdict, and also throw out.
You would no longer be a lawyer.
Same thing. Yeah,
right.
Like, verdict gone, law license goes into the same trash heap. And I've been trying to dig into the law there. I think there's some real possibility that she's looking at jail regardless of the jury tampering. Just the whole thing.
Regardless, okay.
Well, just the aspect of, let's say that the jurors, nothing is sustained with the jurors. Like, they just say, okay, these affidavits are lies, whatever else. What they've got in writing from her saying, here's this contract for the use of the courthouse, but also you have to push my book. That's corruption.
Now, if she promoted the book afterward, that would make sense. Like, okay, you went through this whole trial, you lived it out, everything's done and finished, and now you're writing a book. Okay, no problem. You're not interfering, but this sounds like direct interference and motivation involved for her own personal profiting. Or am I mistaking this?
Well, no, you're absolutely correct.
You can still be in trouble even after the fact. Like Ian's saying, I read the ethics opinion that she sought before she wrote this book. And while it didn't accurately describe her book that she did write, they did list out the number of statutes, like Ian's talking about, that you may violate if you decide to monetize the knowledge that you have in a position that you're holding. So, I mean, sometimes you see these people retire or quit or whatever and write a book, but she's the setting clerk of court, writing a behind the scenes look at this juror really struggled with whether they could be on this case or not. The judge did this. First of all, you have to wonder, did she ever talk to any other jury before this? If, wouldn't you be suspicious? Did she ever hint to another jury? Man, that defendant really sucks. And then secondly, if I have to tell the court something personal that may affect my jury service, do I see that in an article next week on online or an interview somewhere? I mean,
in a book.
In a book.
She did that in the book. I've seen some other copies of portions of the book where she is talking about things that happened in camera proceedings.
I don't know. This is creepy.
I think everybody can agree that it's incredibly unprofessional, that it violates numerous laws. And I think one of the biggest problems, I mean, I completely agree with you, Steve, what you're saying. How many other trials has she participated in? And how else has she influenced other juries? That's a really serious question. You're going to have to go back and look at that now. When
Do you want to know that?
Right.
That's one of those that's a Pandora's box, because if this gets reversed and then jurors come forward and say, oh yeah, that happened to me too, that happened to me too, it could be literally years of trials that are suddenly unraveling. That's a nightmare.
Well, do we know how long she's worked in this position?
She was elected 2021, I think. Can't remember.
You could do a lot of damage in 2 years.
Well, she may have worked in the system before that, probably.
Yeah.
And if I'm a lawyer and, practicing in that area, and I see that, if the verdict gets reversed on this basis, the first thing I'm doing is pulling every file to see if she was involved in it, and just being like, okay, let's go talk to some jurors again, because, maybe there's some shenanigans on my file too, or at least maybe I can make enough noise to make it sound like there is.
Well,
so I guess the question I've got is, with these two affidavits, even though one has some contradiction in it, does everybody agree that at least there should be a hearing by the judge to see whether this happened or not?
No question.
Yes.
Yeah, I think that too.
There was a hearing for Epstein with one juror, or Delane, right? And I'm sorry, go ahead, Chandler.
Oh, yes. I mean, I recently saw an attorney on Twitter who was talking about this, and she said something to the effect that an affidavit that was taken by a paralegal is hearsay. It's not a legally binding document, and therefore it should be ignored. This is a very
affidavits are hearsay.
Person.
Affidavits that tell you what somebody else said is double hearsay. An affidavit that tells you what somebody else said is triple hearsay. An affidavit that's hearsay can be used in a motion. And double hearsay, it's going to be up to the judge whether they let it in or not. But you have to for this. I mean, you've got to go forward with this, I think.
Right.
But all affidavits are hearsay.
They're just all these legal professionals who were very, ecstatic to see Murdoch get convicted, who are in, this area, who are very against him. And I've just seen a surprising, Eric Bland in particular, his commentary on this case, so making many excuses for everybody. And, they're all like, we know this looks really, really bad. But
he represents some of the people involved in this now.
And now jurors. He's also representing jurors, he said.
Like four jurors and her, I think.
I know for a fact that he was representing the Satterfield family in the slip and fall accident. Gloria Satterfield was one of his housekeepers. And there was an accident, that was connected. There was an insurance scam her sons were suing. So Eric Bland is definitely biased. But he's also done a lot of commentary on news.
See, that shows his failing as an attorney, that he has an inability to separate his claims, his arguments, his situation from the double murder trial. Right. They're completely separate things, regardless of how bad the judge wants this to become a financial / murder trial. They are separate trials. They are separate things. They are separate claims, civil claims. And again, I don't care if he did. If you want to convict him again, do it. Go ahead.
Just do it right.
But do it fairly.
Absolutely.
Well, you want it clean, don't you? I mean, it's you expect it coming from the wine moms and the lawn crime chat and all of the podcasters who grifted off of this. And I don't begrudge them anything there, but you don't when you see it from a lawyer, it's just kind of disappointing.
Help me out with the double jeopardy question, though. When you say, convict him again and do it right, well, I'm confused, because my first question would be, well, they do have the death penalty in South Carolina. So what if it gets retried? It's like, well, you know what? This time we're going to go for the needle. Can you do that? I mean, somebody help me out. Gosney, this seems like up your alley, but
Up yours, Gosney.
what about,
Yeah.
I mean, in the nicest possible way.
Thank you. No, I appreciate that. Well, yeah, so somebody had brought that up, and I'm not sure who it was, but I think it was Jeff of Legal Vices here. But yeah, that's a very interesting question because, okay, generally an appeal on this basis would entitle you to a new trial. Okay, so let's assume that one of these allegations is sustained and a new trial is ordered. The next step would then be for the defense to file a motion to preclude the second trial based on double jeopardy principles. Now, the way it usually occurs is if it's based on prosecutorial misconduct. Now, this is in Florida, of course, I'm speaking as a Florida lawyer, but there's usually similarities among state laws. So the way a second trial would be barred is that the prosecutor engaged in such egregious misconduct as to preclude a second trial based on double jeopardy principles. So
now, does it have to be the prosecutor, or can it just be an agent of the state?
That's my question.
That's a very
That's
you're
my
a
question.
lawyer. You should do this
know.
for a living. That's exactly the question that I don't know the answer of in South Carolina. But you would obviously, if you're a defense lawyer, you would make that argument that these people were the agents of the state and engaged in this egregious misconduct. And the fact that SLED was involved, especially the one allegation where SLED was actively involved in getting the swing juror off the jury, to me, that's executive action and that you could attribute that. There's a lot of case law from the U.S. Supreme Court that law enforcement and the prosecution team are one and the same. So I would definitely leverage the SLED action and attribute that to the prosecutor's office and try to bar double jeopardy. So it's possible. It's possible.
And did you guys see the fact that SLED officer that lied to the grand jury was voted the SLED Officer of the Year for 2023?
Yeah.
There's a reason why on my channel I do a still a cop versus not a cop sequence, and people say, oh, well, we always know the answer, which is that they're always still a cop. It doesn't matter what kind of issues, but lie to a court, Officer of the Year. Great.
Yeah.
And just
Qualified
keep in mind when you're driving down the street and you see sirens and lights behind you, that guy might be somebody like this. I always make the comment that good cops deserve to work with other good cops, but that's not how it works, unfortunately.
And I will say that this trial has shined a very negative light on the entire South Carolina system, criminal justice system. I watched that trial pretty much front to back and have commentated on it. And I am very disappointed in SLED, the prosecution team, the judge, and now the clerk, and the entire system seems very corrupt there. Now, and I know that people are saying, well, he did it, but I don't care who it is or what happened regarding if this guy is the serial killer of the year, right? The fact is, all of these people are entitled to a fair trial. And when you have this kind of corruption front to back, I mean, it is sad. I really feel sad for the people of South Carolina. So, and I will say that somebody had asked in the chat about jury misconduct and how common is that? Well, I will say that I would refer people to an interview that I did with Mary Rose Peterson of juryinvestigations.com. And she was her husband was a former client of mine. And he faced life in prison. He was sentenced to life in prison, but then is now out based on jury misconduct. And she developed a business model off of her investigations of her husband's case to uncover jury misconduct. And I think she's into basically over 70 cases where she explores juries for juror misconduct. she said something profound to me. And I mean, it's hard for me to even, as a lawyer practicing, we don't look behind that jury curtain very often. But she said in all of her investigations, she says every trial that she has investigated, there has been some amount of juror misconduct, either through non-disclosure of conflicts, of issues, of prejudgment, of something that they have done, which it's hard for me to comprehend. And she has so there's an interview. If you want to go back on my Rumble channel, you can look. It's called Life in Prison to Freedom, How Jury Misconduct Can Be Discovered. Mary Rose Peterson, and she tells her story about jurors, and great guest if any of y'all ever want to interview her.
I definitely do. Please hook me up. I have a worry about that though, because if that is in fact true, that statement you made, that would imply the entire jury system is correct or run. I mean, they're screwed. Where do you go?
Well, no, I wouldn't say that. What I would say is that what we defense attorneys and attorneys generally need to do is be much more vigilant about our jury voir dire questioning. I think we take it for granted that people are telling the truth, and we don't double check, and we don't do enough front end vetting of jurors. And
Steve, let's go back to the thing that I have to this day never figured out is how one of the jurors that is on that jury, how she is still on the jury when her husband was literally the first officer to arrive on the scene.
Oh, it's insane.
Yeah.
How she is still on the jury is utterly incomprehensible to me.
And whose fault is that? If both lawyers agreed,
they
didn't dispute. I mean, I would think that the defense or somebody would say no. But if both lawyers agreed, then isn't that?
I mean, if
I
was
a challenge,
if I'm the judge and both lawyers are agreeing, but I still find that out, I'm like, I don't care if you're agreeing. That's cool. I still have an obligation to manage this, and no.
But if you're Judge Newman, you'll allow it.
Yeah.
I mean, that's really his motto is like, I'll allow it. The jury will
figure it
They'll
out.
allow anything.
Well, okay, this is a dark day.
And
let's shift into letter writing. Let me see. So somebody, I think Chandler, you're covering the famous scribe who doesn't like her lawyers.
Well, Southern Law Steve and I are both covering it, and he did the video first, so I actually think that we can collaborate on this one.
Perfect.
Plus, I'm working with MLS Law, but he's in Sweden right now, so
he's in the chat too.
Oh, is he? Oh, hi. Welcome. So Sarah Boone has been writing some really interesting letters to Judge Wooten, and they seem to be press releases more than anything at this point, but they're long and angry. And she's frustrated, but we'll see what happens. I'm curious. Well, Steve, did you read through the letters on your?
Yeah, when I saw them, I just went ahead and made a stream and read them live for the first time. And she was at maximum frustration. But at the hearing today, the judge didn't demonstrate the level of empathy that she was looking for, because she gave him a specific set of instructions to follow on how to vet the next attorney, how to handle the courtroom dynamics, how to handle the administration. And he wasn't following that script, so I was watching her outline her next missive in her head. But she does have a seventh lawyer, and that lawyer is going to need all the luck that number 7 implies. Because
she has another one, really? So she's not going pro se.
Winston Hobson is appointed as a new counsel.
I'm relying on you because I'm actually not caught up yet. So
I streamed that a while ago. The new lawyer is Winston Hobson.
Okay.
Well, the 6th lawyer that left, I have never, ever in what I've been doing this for 29, 30 years now, I have never seen a lawyer who says, look, the only way this is going to go forward is if she represents herself. I have never seen anything like that. How bad do you have to be that your lawyer goes, look, this is so bad that she ain't going to be satisfied with nobody. She's got to represent herself, Judge, if you want this to go forward. That is a frustrated lawyer.
So what is the recourse then? I mean, can a client be so obnoxious that you have to go for it? Well, what happened with our guy who liked to run people down? Isn't that a similar scenario?
Well, he was a sovereign citizen, so he was into that from the beginning.
And
but
he didn't want counsel, I don't think.
Yeah.
The judge told her today that if you develop a conflict with this next lawyer, because it's not like she had a personality conflict with all the lawyers, because some of them got out quickly due to professional conflicts like witnesses and stuff. But he told her, if another conflict develops, I'm going to start looking into this carefully, into who's generating these conflicts. And he kind of read her the riot act to some degree. But she's laid out, she told the judge, stop throwing darts, aim for the bullseye, give me the lawyer I need. Maybe Winston is the bullseye. We'll see. For Winston's sake, I hope so.
Poor Winston.
Well, I wonder how many other cases he's working on. By the way, I hope my audio issues are resolved. I noticed that might have been a problem.
Yes, it's not clicking now as much.
She also complained in her last letter that this lawyer that just got out was using recycled experts. In other words, experts that had been appointed earlier in the case. He was relying on some of the things they did, and she didn't like it, which implies to me that perhaps that expert didn't give her the testimony that she was hoping would come forth, and she needs new, better, exciting experts right out of the package, and that's why they wanted the $400 an hour person, maybe.
Well, it took
an expert who's never testified before.
Who's paying?
The universe of experts that you can find. I mean, we hire a lot of experts in our office. It's a relatively small pool of people that you're tapping into. So, and those people, I will say that at least from the defense side, I've always found them to be pretty honest, and they're not going to stick their neck out for somebody like Sarah Boone to give her some opinion. This whole idea of, I see the paid for opinions become much more prevalent on the state side, but usually that's not because they're being paid to give the opinion on. It's just that they're so pro-prosecution that they see everything through the prosecution lens, not that they're being necessarily dishonest. And so I expect what Steve said there was right on the money. They're not giving her the opinion she wants. And, that's you're just going to have to live with that. You're not going to get an expert to say that any of these things was a cause, or to come to the conclusion that she wants to have happen. It's just, I don't see an expert giving this opinion that she wants. The fact that she put this guy in a suitcase and killed him to death was generated because she was engaged in some kind of,
It's the battered spouse defense. She wants
battered spouse.
It took a long time
there's
to
these
get
people
an
deal with battered spouse. They see battered spouses all the time, and they're going to look at this and say, "This ain't it."
Well, it's almost never successful as a defense. It's very unsuccessful.
Yeah, we saw that in the Taylor Shabusiness trial there in Wisconsin, where her first lawyer asked for a mental competency hearing. Her first public defender comes back. He says, "Well, okay, we'd like a second opinion." And the judge said, "Okay, are we just going to keep doing this until you find someone that says what you want to do? If you want to do them on your own dime, go ahead and appoint your witness. Go ahead and appoint your expert witness." They did that, and the one that the defense paid for came back and said she's competent. And then they went and she's finally went with the guilty by not guilty by reason of insanity or whatever it is in Wisconsin, which triggers another one that found her not guilty. 5 times she was evaluated, and 4 of those 5 said she was competent to stand trial. So where do you draw the line? Where do you go? Okay, you're done. How many of these opinions do you want? How many of these experts do you want to burn through? They're just not giving you the answer you want. Doesn't mean they're not competent and not good experts.
Well, the suggestion, they're two different things here, and they get oftentimes conflated. The suggestion of incompetency in Florida can happen over and over again. But it depends on the defense attorney who, you have problems communicating with your client. It's obvious that you're having competency problems. That's different from an insanity defense. And what happens is, though, what we find is that when somebody's genuinely incompetent, they get sent off, they come back, they restored to competency because they're read a sheet to say, "Do you know who the judge is?" And they recite it. And then what happens? They come back, and then we try to deal with them again, and they're still incompetent. So we do another suggestion. It kind of goes around in this running mill. And until they're found permanently incompetent, the state keeps trying to find a little window that they can sneak them into trial to get them convicted and send them off to prison before an incompetency suggestion gets done again. That's kind of
we're not arguing incompetency in the Sarah Boone trial, but I just mean, how many experts do you go through until you go, look, you've had your fair share of experts. You choose one and go with it, or you get none.
And she's had a bunch. I was surprised by how many have been appointed for her.
it took a very long time to get the last, most recent expert for this particular defense, though. That was why they had to delay the trial a couple of months ago, correct? That's what I
Well,
recall.
that's true, except that there were prior experts appointed long ago when the pro bono attorney came in. The court was approving. I did a stream on it where I downloaded all that stuff. I think she's had like 10 experts appointed, and some of them were psychologists, psychiatrists, and people in domestic violence and stuff. She just hasn't gotten the answer she wanted. That's why she's complaining about. And so she wants another expert. This expert would not be touching novel territory. She's just hoping they'll give a different opinion.
And I expect this issue is impacting her relationship with her lawyers too, because as a defense lawyer, you're going to talk to her. You're going to say, look, you don't have a defense. You need to plea. You need to focus on the sentence, mitigating the sentence, getting away from a life in prison. And she's not wanting to hear that. She does. That's a hard, cold pill to swallow. And that's not the answer she wants to hear. And so she yells at the attorney. He's not doing his job. But people think your job as a defense attorney is to, get you off. That's not the job. The job is to advise you. And the advice I'm sure these defense attorneys are giving her is plea, throw yourself in the mercy court, try to get something less than life in prison.
I have a question about experts, and correct me if I'm wrong, or I actually have no idea. You can't, I would think there would be some sort of ethical or professional responsibility that you can't just land on an opinion that you're paid for. I mean, you have to have something to back it up, right? I mean, couldn't an expert get in trouble if they're, for sale, so to speak? You're shopping for an expert and, yep, here's the opinion I want. Or is it just a reputational thing? I mean, somebody talk to me about experts and what their actual responsibility is or liability.
Well, I mean, go ahead, Runkle.
Where I am, if one of the first questions you're going to ask an expert is, have you ever been found, or has your opinion ever not been accepted by the court? And so if you get somebody in a position where they're like, oh yeah, here's this opinion I gave, and it turns out to be complete crap, and the court won't accept it, it's like, well, you're going to have a real hard time the next time, because why wasn't your opinion accepted? Well, all right, is it not this case where you were found to be, an expert for hire? Good luck. That just kind of ends your career.
And I mean, Steve can probably speak more to it, but when you're talking about the vagaries of social sciences, psychology and psychiatry, you can pretty much say, in my own personal opinion, this is what I see. Even if it's ridiculous, that's still your professional opinion as someone who's talked to the person for a nominal amount of time, because it's not a hard, fast science.
Well, and I'll say from the civil side, even in the hard and fast sciences, that you still a lot of construction litigation and some intellectual property litigation. So you've got engineers testifying on both sides, right? And still both sides are going to have an expert say, oh my God, this structural element is defective. Oh my God, no, it's not. Oh my God, this is similar to this item in the patent. Oh my God, no, it's not. They're all paid a lot of money. So I never saw that a side couldn't get an expert. Now, if the expert doesn't want to say what you want, that's called a consulting expert. And the one that does say what you want is called a testifying expert. But what you do want is a relationship with good experts, that when you take a case or you're getting into a case, you may never plan to call them, but you need good, honest opinions on what's the strength and weaknesses, because you don't want, kind of like what Ian alluded to, you don't want some expert bamboozling you and getting a check saying, I'm going to go into court and support your case. And you don't understand, because you're not the expert, why he's vulnerable. And then he gets blasted in the deposition and your case value collapses, or worse, blasted on the stand. So experts are a tricky subject, I think, in civil cases, at least because of the different things you might want to use them for.
So you want to hire an expert that would be devastating to your case to do the consult, in other words, so you can find out how bad or good your case actually is.
That might be like somebody going and shopping all the good lawyers in town who are divorce lawyers about their case to conflict them out so they can't go up against them. People would never do things like that.
Yeah.
Could
you call every lawyer in the phone book and ask them some questions.
Let me tell you this detail about my case. Yeah.
Oh, nice. Okay, this is a strategy session, folks. This is not legal advice.
It's life coaching. It's
I
what
can
you
tell
should
you
never do.
It's also a really bad idea, at least where I am, because if the court finds that you've done that tactic of, like, let's conflict out all the, all the lawyers, it'll be like, okay, we're going to bring in a lawyer from wherever the hell away, as far as you didn't go, and it's going to be entirely on the other side who did the shopping, like 100% of costs, including like flights for every court appearance and every meeting and so forth. It can end up being like, hundreds of thousands of dollars of, the court being like, nope, you can't do that. So
Kanakistan is so much more reasonable than other places.
it's tough to prove, but I've seen people bring in like, here's 10 affidavits, or an affidavit saying I spoke to these 10 lawyers. Each of them was conflicted out. And then it'll be like, well, we're going to inquire into this. So, yeah.
I don't know who this is, but I agree with this comment.
Yes, it's just life coaching in the abstract. It's in the air. It's ethereal.
Right.
Hypothetical life coaching. Okay.
Right.
The next subject, we've gotten through lawyer shopping. What was it? Jeff, I think you said tangentially you know something about it. I'm hoping Chandler might too, but this beef with Logan Paul and Dennis something or another over Logan Paul's fiance.
Well, what I know about that, and again, it's just tangentially from the stuff that I just scroll through as I'm trying to wake up in the morning, is he's got this fight coming up with this guy, and the guy, Dennis, whatever the hell his name is posting pictures of people, like old pictures of her going, oh, I haven't got any D in a while. I'll take any D I need like old pictures, as well as new stuff using people that look very, very similar to her, performing fellatio and things like that on him. And finally she stepped up and she filed for a restraining order against him, which is a good thing. I mean, it's just, it's playground tactics that have got out of control in the new realm of the internet that we're looking at, the realm of social media.
We were discussing this with Ari Jacobs, I believe, and I think that she knows them tangentially. And I asked her specifically, could this be orchestrated? I think that with if there's a restraining order, which that's new information to me, obviously it's not, but it kind of looked for a while like maybe this was something that everybody had kind of, created to make some sort of elaborate publicity stunt to get more eyes on this fight. I don't think that's what's actually happening. It seems
she filed for a restraining order, I guess was yesterday U.S. time.
Yeah.
But now,
She's
can I
genuinely upset.
I mean, we need to see, who are we talking about? Do we have any picture evidence of who
I'm
we're
sure you
talking
could find
about?
something, Steve.
I don't know.
There is.
I'd like to
There's
see a
like one picture of Logan Paul. I mean, he's a big
I don't want to see Logan
guy.
Paul. I want to see
but
who this woman is that they're fighting over, because I think it's very important for us, for our legal analysis.
Yeah.
to know what we're
Steve
dealing with.
is very concerned about proper imagery that is going on, and notice that Chandler leaves the channel right in time for this, but
Good timing.
I think this is something that he's talking about here. This is Nina
there you go.
Agdal, but I did see some of the back and forth in the comments, because I know Ariadna and her tweets about it, etc. I'm sorry, I'm not trying to complain too much, but they were out of hand. Like, I could only hope that this guy never has a daughter. I'm sorry, the viciousness of those comments over and over and over.
About the guy's
I don't see how it's
fiance.
not. Yeah, I don't see how that is not complete harassment. I would love to get anybody's opinion on that, but it was really, I feel like, just going too far.
The proverbial straw that broke the proverbial camel's back was the video of her allegedly performing fellatio on him, like Logan Paul's fiance performing fellatio on him. And that was instantly proven. Like, this other girl had tattoos on the back of her neck that Logan Paul's girlfriend doesn't. But I mean, it seems like it legitimately traumatized her to the point that she did file for restraining orders against this guy.
Yeah, and that's the other thing. Okay, here, Logan Paul's fighting Dylan Dennis in a celebrity boxing match, right? This is talking trash about his fiance. It's not him.
Yeah.
I don't mind the trash talking at the MMA, the fighting, whatever. It's like when they're trashing each other,
Part of the
that's one
culture.
thing. But going after the family,
Well, that's just a bro code thing. You don't bring wives and family members into things. That's just a bro code thing.
And there's no
It's just a
reason-
human being thing. It's
There's
Yeah.
there's no reason for it. It's not necessary. He could go over, a number of other things that are related to Logan Paul's actual, his character or his fighting abilities or,
There's
your mama,
there's enough
whatever.
to hate about him. You don't need to bring anyone else into it.
yeah, and okay, people are in the chat. Nobody said that he doesn't have free speech. Nobody's saying it's illegal. We're saying he's an asshole. Okay, there's some free speech. It's
that was-
disgusting.
Well, to
And it can be-
paraphrase Mark Twain, he said something like, "We have three inalienable truths in America: the right to freedom of conscience, the consciousness, the right to freedom of speech, and the good sense never to use either of them."
Mhm.
So just because you can do something doesn't mean you should.
So if I walk into a bank and hand the teller a note that says, "Give me all your money or I'll kill you," and they have a problem with that, can I just say, "Hey, free speech, bro"?
You have to make sure you put First Amendment in
Yeah.
parentheses.
Okay. Yeah.
Yeah.
So I mean,
That's not legal advice, by the way.
Right. Yeah. It's life coaching.
Good point.
Sometimes
Anyway.
there's a line you cross, I guess is the point I'm trying to make. But I don't, know as much about this case.
Right. And I mean, obviously that's not exactly the same. And yes, he has every right to say that, but why? Why would he? And I don't know. It's like, what if Logan was saying it about his sister or his mother or something else? Why can't they just pick on each other? I don't think that's a terrible thing.
I mean, you've got to be pretty horrible to make Logan Paul look like the better person.
Right.
Good point.
I mean, there's so much material there, is the thing.
Mm-hmm.
There's a lot of material. And he's just completely ignoring that to, take something, from his personal life. He's engaged, he's happy. Like, let him enjoy, she didn't do anything to him. Why does she have to be and then obviously it's putting a spotlight on her. It's, a lot of other people are now coming in and harassing her, creating problems for her, his fans. And I just don't agree with doing that. I think you should be, thinking about how your fan base is going to react and respond.
Yep. And somebody's saying because he can. Okay. There's a lot of things people can do that doesn't necessarily make it a good thing to do. But
I mean,
whatever.
I can say anything about Chandler, Eric, Gosney, Ian, Steve. I can say anything I want about it, but that doesn't mean I should. It doesn't mean I'm not an asshole if I do. Just be an adult.
Or have some class.
Maybe
little?
I'm just too old. I just don't understand this. Just like acting childish and stupid and doing stuff just for shock value. I guess I'm just too old to be part of this anymore.
Well, there's
Yeah,
a particular
it's the same-
culture that goes along
I
with
was-
that kind of thing. With fighting, with boxing, that is particular to it. How those boxers interact with each other, and there are rules that are internal to people who do that sort of thing. And I just think that it crosses a line, but I'm not part of it, so I don't really know. I'd like to know from other boxers, who are part of that. How do they feel about it? What do they think?
No, but the face-off between Ali and Frazier's, I mean, that was just them staring each other down.
But that's
And I
true.
was
They trash
intimidated.
each other.
Yeah,
That's the key. I mean, Conor McGregor, I don't think I've ever seen him go after family members or anything. I think
When he broke his leg, he did. And remember, Joe Rogan had to spit down there and interviewed him, and he started slam dunking Dustin Poirier's wife.
really?
I was like, McGregor, what are you doing here, bro? Oh, yeah. He was basically calling his wife sort of the things that are being said here, I think. But, his leg was snapped into at that point.
Yeah.
So
Okay.
he might not have been in his right mind at that point.
All right. Well, a bad choice then, on my part. In general, though, it seems like they talk about each other, but whatever. Okay, what was it? We had some other cases. Steve, do you want to talk about the RICO action? I think you were starting to look into that.
Talking about me?
Yeah. Oh,
Yeah.
sorry. Southern Law Steve's.
Well, I did glance at it a little bit. So, of course, they have filed this RICO action against Antifa people for attacking that training center. And I'm not surprised that they're trying to find a way to go after these people, because it's long been known that there's a level of organization there and moving money and people around in order to amp up violence at different events. That's been going on. I don't know the specifics of what they've got to support all of that, but I'm not surprised by it. And I think, at least some of those people need to find their way inside of a jail. I don't know about all of them, but the RICO thing has been used, of course, against Trump and his co-defendants. So it seems like it's becoming a popular tool around there to go after people in criminal court. I think it's a ridiculous thing to use in the Trump situation. I don't know if it's ridiculous or not in the other one. I haven't read the indictment and the Antifa thing.
Well, I think the interesting point is the irony involved in that. RICO's been around since the 50s, if I recall correctly, but it didn't do anything until the 1980s when a certain particular attorney general named Rudy Giuliani finally figured out how to use RICO to bring down the New York mob.
It was designed for the mob, though.
Yeah.
I think Dershowitz said he helped to write it.
Yeah, but nobody knew how to use it effectively until Giuliani came along, and he brought down the 5 families in a matter of years. And ever since then, RICO has been used as a weapon based on Giuliani's roadmap for using it, and now it's being used against him. I think that's just like an incredibly ironic situation, right or wrong.
Oh, yeah. There's something, you've heard of Occam's razor, right? Elon Musk was speaking about this, and I'm calling it the ironic razor. And it's essentially whatever the outcome, it'll truly be ironic. Anytime you look at an incident.
That's an interesting take on the principle of parsimony. I like it.
Well, it's true. I mean, and it came out of Elon Musk because they were talking about Elon Musk is the main guy who is afraid of AI. It's going to take over the world. It's the biggest problem. What is the biggest AI function now? OpenAI, ChatGPT. Who co-founded OpenAI? Elon Musk. Whatever the outcome, it will be ironic. Rudy Giuliani, as you just pointed out, Jeff. Here we go. How do you feel about this, though? Because RICO was supposed to be designed as a way to get to organized crime, very specifically because they were smart enough to have layers between them and the events that were happening. But now it's like, okay, well, we can just apply this brush to anything out there.
Hate it.
Is this a problem?
I personally hate it because here's a little Legal Vice's origin story. I used to be the president of a motorcycle club here in Korea. And so I understand this idea of the wrongness of saying, okay, just because a certain few members in a group are doing bad things mean that everybody in the group is colluding to do all sorts of bad things together. Just that, that's the hypothetical you start with as a ground for your claim. And I just hate that. You don't have to prove that they actually are. You just say, oh, because they're the group, you get to assume this from the get-go. I hate that.
So do you think there are constitutional grounds to go against RICO? I mean, is it a legitimate thing or not? I'm really asking. I don't know.
Well, I may be totally off my rocker, but I just think it's a crutch. It's a crutch to fill in the gaps between constitutional arguments.
Right. Well, this is the problem, and there's 2 concepts that are not regularly applied enough, and this touches on one of them, and that is the legal concepts of overbreadth and vagueness. And I think that both of those things are implicated on a number of statutes that we're seeing regularly abused. One of them is conspiracy, another is obstruction of justice, and a third is RICO, which is basically an amplified conspiracy. And because it is overbroad, because it applies to so many things that it is not specific as to what is being charged. Conspiracy is also engaging in agreement. And there is the case law that you can actually agree with the government. One of those people can be a government agent. And then you have obstruction of justice, which is also overbroad. And I have made those arguments. I've actually petitioned the U.S. Supreme Court several times on the obstruction statute in Florida. But what it comes down to is you have something called a legal catch-all. And if you have something that is a legal catch-all, that to me is unconstitutional under the overbreadth and vagueness argument, because that means, well, we can't get you on anything else, but we've got you on this because it applies to everything. Such a statute should be not existing. And for some reason, our courts, and this comes from a lot of our pro-police, pro-law enforcement, anti-crime folks who are on my side of the aisle, always want to bend over backwards to get the bad guy. And so they end up supporting these kind of overbroad statutes because if you're against them, you're pro-crime. No, I'm for fairness and I'm for the rule of law, and these type of things are anti-rule of law.
Right.
Well, do you see? Because my big worry about it too is that it's obviously being expanded, and
which is what happens. See, that's what happens when our clients. I represent very poor people who are on the bottom rungs, right? And it's like, well, who are they? They're throwaway people, and their arguments get tossed aside by judges who are in an elite class. And then what happens is it feeds up from the bottom, and all of a sudden all this case law is made that's anti-citizen and anti-individual. And now all of a sudden it's being wielded against the regular citizen, the middle class in the middle of the pump, and people are shocked. This is why everybody's entitled to a fair trial. We should apply rule of law equally amongst all, because the people on the lower end, that's just the leading edge. And the government wants to always expand its power, and the institutions that are supporting it, like the AG's office, the judges, and they're all part of the state, the entity of the state, and are pushing for greater and greater state power. And there's a natural arc of evolution towards state power. And the reason for that is because the state can always push for more power as their major interest, whereas I represent an individual defendant. And if the facts are not favorable to the state, they just dismiss it, they get rid of it, they plea it out, they drop it. Whereas the state can always push bad facts to expand their power. So you get this arc of justice that aims towards greater and greater state power. And we've crossed sort of a Rubicon. I think we crossed it about 10 years ago, but we've crossed this threshold now, and we're really seeing the impact in our society through all of these unchecked prosecutors and unchecked prosecutions. Basically, we're living in a country ruled by prosecutors.
Well, I think you hit on it, Steve, there with that idea that it's the prosecution. The prosecution works for the state; they prosecute you, but it's also the state that gets to arbitrarily decide who they consider to be a criminal organization.
Right, and if you like obstruction of justice, what does that mean? Well, that means contempt of cop. It means and there's case law on this. And like I said, I've brought this to the attention of of the U.S. Supreme, but it's never been granted. But the institutional power, the judges and the appellate process and the prosecutors love to have a legal catch-all because it forces people into difficult plea agreements. They get this one thing I really hate. And now I'm on the Gosney rant.
One thing,
amongst many things, amongst the many things that I hate, is this idea of statistics being applied in a prosecutorial grant. So you get, we never lose a case, or we got this thing, and where it's like, okay, so your client is guilty because your statistics say that he must plea in order to maintain that statistics in a prosecutorial setting have nothing to do with justice or the rule of law. Nothing.
Well, and in fact,
go ahead.
When I see them bragging about like we always get a conviction, I'm like, that's not a thing to brag about. That's actually a grand indictment of yourself, because you're gonna get it wrong sometimes. And if that means you've convicted everybody who you've gotten it wrong about, that's scary.
Right, it's true, but it's hard for citizens to judge the criminal justice system, the effectiveness of their prosecutor team, and really translate what's being said on the political stage into a vote. So it's an easy thing for people to brag about. I'm the tough on crime, and I always get the conviction, right? When that really is not the function of the prosecutor's office. It's to support the rule of law by applying the rule fairly against all. And representing the citizen who's accused just as much as the victims of the family. Their job is to apply the law. Like, that's why whenever amongst the other things I don't like is prosecutor cheating at trial, and specifically closing arguments, because to me, every time they cheat at closing arguments, they are undermining the rule of law, which is directly contrary to their mandate as a prosecutor. But we have this us and them victorious role. We have the idea that we're going to win as opposed to we're going to uphold the law. And that's where you get this. And why would you want to win? So we can maintain our 100% conviction ratio, right? All very unethical and wrong.
Can you guys confirm this, chat, whether this is true or not? Because it would be a factor.
Yes. Well, another thing like I'm dealing with right now in my brief, I don't want to dominate anything here, but there's all this deference to the standard jury instructions in Florida. Well, the standard jury instruction committee is dominated by prosecutors and shoot down any suggestions from the defense. And then they bring it into court and say, well, the committee has considered this, and this is the instruction, and this is the law. And then the judges say, well, we'll defer. I mean, some judges are very good. I had one judge say, I was on one of those committees, and I know where they come from, right? And the Supreme Court of Florida actually says we don't endorse these. But there's enough judges that do. They just say, well, it's the standard instruction, so I'll defer. And actually, Chandler, I'm trying to recruit Chandler for my next law review article on the reasonable doubt instruction, which is a disaster in Florida.
Well, I've already said yes. I've said yes, Steve. So
yes,
we're on.
You don't know what you're buying into, but I want to come up with a
Maybe not.
proposed instruction that can be given, because the reasonable doubt standard, the core of the criminal justice system, is in Florida at least, is so confusing and flawed. Now, if I'm a prosecutor and I don't like the reasonable doubt standard because it's too hard, then I can't get rid of it. But what I can do is I can muddy up the instructions so much that nobody understands it, and then I've effectively undermined it. So I'm trying to, my next article, I think, maybe directed at coming up with a coherent special instruction related to beyond a reasonable doubt standard.
Is this a pattern of behavior? Because, I mean, technically the prosecutor works for the state. The judge ultimately works for the state because it's taxpayer funded. They're supposed to be independent. But does that have a built-in problem, just the incentives of, you work for the state and you follow into the state?
Elected judges ends up weighing, and it's the same thing in Canada where we have appointed judges. There's a bit of a finger on the on things because nobody wants to elect a judge who acquits too many people. It's really easy for them to point and say, oh, this person, look at this guy who was charged with terrible crimes. And this judge, presided over an acquittal. So you get that. You get,
but it's not the judge acquitting, though. I mean, to be realistic, I'm sure that they market it that way, but technically, isn't it a case of applying the law and sometimes you can't acquit because the law doesn't work out?
Well, a good example,
how do voters think about it?
A good example is the judge in the Parkland shooting case. She was an elected official. She's a political appointee, and she was actually sanctioned by the Florida Supreme Court for her behavior in that trial, for being so biased, being aggressively anti-defense. And what was she doing? Yeah. She was showing off for the cameras how tough she is on crime, how much she hates this defendant, and she's with the victims and all this. That's not her role. Her role is to is to allow for a fair trial in a fair courtroom. And she did not do that.
Wasn't she hugging them?
She hugged the prosecutor. Yeah. The way she talked to the defense was so disrespectful. I mean, if you saw, she told the elected public defender she wouldn't give him time to talk to her defense team. She said, you just get out of here right now. She just get out of here. The things, I don't know if I told you, but I actually talked to one of the Parkland shooter trial jurors, two of them, at our recent conference. And they even picked up on that the judge was being unfair, although it wasn't a determinative factor.
Well, and also think about when you're running for election, if you're a defense lawyer, because what they're going to do is they're going to drag through all of your cases and say, this person was standing next to this horrible criminal. And, here he is arguing that this person should get less time for a murder, a sex assault, a whatever it is. Here is, are you going to vote for this person who stands with criminals? So it's a lot easier if you want to be a judge to start out in prosecution.
Yeah, well, and it's sad because we see some great judges too. The judge we just saw in Vices and what was that Tampa judge we've seen a couple times?
The guy.
Excellent judge.
That guy.
The guy. Yeah,
So
that guy.
memorable.
Face, nose, got a nose on his face.
Yeah, the guy that looks like looks like Dr. Bunsen Honeydew from the Muppet Show.
A little more specific, yeah.
He's kind of like round.
And I'm trying to think what was the last trial I covered, because that judge was also excellent.
Well, it was a Peterson trial, wasn't it? Was that the guy's name? Can't remember.
I'll find it just a second.
But yeah, great, anyway, great judge. Fantastic judge.
Well, since we're throwing everything out there, let's talk about mandatory minimums. What are your thoughts?
Don't like
You're
it.
hitting all the hot buttons, aren't
Well,
you?
okay, come on, let's just keep it going here.
Well, yes.
I think they're
Go ahead, Ryan.
I think they're a terrible injustice. They're contrary to all of the principles we should have, and ultimately they are a weapon for especially unethical prosecutors, because it's really easy to say, listen, we've overcharged you with this thing that's got a mandatory minimum, but if you plead down to the thing you actually, we should have originally charged you with, we'll take that off the table. That starts looking really tempting to somebody, but the only people that mandatory minimums hit are the people who should get a break. Because if you've got somebody who's super sympathetic, they might be the one getting the sentence under it. But the person who's super, who's the worst person you can think of, they weren't looking at a mandatory minimum, and they aren't looking at a mandatory minimum when they go in for sentencing. They're looking at some serious sentence. So really it goes after the people who most deserve a break, and it's this weapon that gets people convicted. It gets people to plead guilty, because what options do they think they have? Like, are you gonna it's a lot easier to do 2 years in jail than it is to risk doing 30 as at a mandatory minimum. And if you're given that deal, if that's the choice that you've been pushed with, is plead out and get 2, or fight it and maybe get 30. A lot of innocent people would take that deal.
I go back to the 3 strikes and you're out minimum mandatory. 3 strikes, it's life imprisonment without parole. And the was that a Florida? I think it might have been a Florida case where the guy had 2 legitimate strikes against him. His 3rd strike was stealing a slice of pizza, which triggered a minimum mandatory life imprisonment. No,
it's tough. I mean, there's 2 points. One is the Shabitness trial. The judge in the Shabitness trial was probably the best judge I've seen in a trial setting on YouTube, and Vices and I covered that a while back. On the minimum mandatories, I will say that the thing that really bothers me in Florida is our 1020 life statute. Florida gets the reputation as being very pro Second Amendment, pro gun, and Ian knows this, and one of the things, though, is that we have this 1020 life statute, which pretty much undermines all of our very, I'd say, self-defense oriented statutes, because if you lose the game, you're facing life in prison, mandatory, no discretion. And that basically undermines, okay, so you've got all these protections, but if you lose the dice roll, then you're going to go away for life. And that dice roll, a lot of times prosecutors will use that as a weapon against defendants to force them into pleas. So if you're facing life and they offer you 5 years, and you even say, I've got a self-defense claim, are you going to push your self-defense claim when they say, well, if you push the self-defense claim, we're going to take that offer off the table, which is what they do every freaking case.
And Canada actually used this. The Supreme Court basically made this argument in a case called Nur. And what Nur was about is there's a mandatory minimum for if you're found with a handgun and ammunition. And there was the Crown here, so the prosecution can proceed either by indictment, which is sort of a felony equivalent, or they can choose to charge it as effectively a misdemeanor, so by summary conviction. If they proceeded with the less serious, there was no mandatory minimum. But if they decided to go by indictment, so the felony version effectively, there was a 3-year mandatory minimum. And the Supreme Court said, listen, even though they couldn't show specifically a situation where it had been abused, they said this will be abused. There is a certainty that there will be people who are told plead guilty and will let you go with the misdemeanor version, Or if you want to fight it, we're running it as the more serious, and you're looking at 3 years. The Supreme Court said this is unjust and can't be allowed to happen because it's going to end up harming. And they specifically pointed to the less involved person, because here we have firearm licensing. So if your license expires and you just forget about it, well, of course you have the handgun and the ammunition, because who doesn't have both? And so they're saying, like, that person who could be like, a grandfather who just likes target shooting, they could hit them with a threat of a 3-year mandatory minimum in order to get them to plead. And they might have real, constitutional arguments, like the search might be bad or any number of things. But who's going to take that if they're saying, oh, well, and what they would do in Canada, the tendency is to say, listen, we'll give you just like a fine and a gun ban. So, if you're saying, oh, well, I have to give up my guns versus like risk 3 years, nobody wants to roll the dice on 3 years.
Well, and just talking about the arc of the law towards state power, it also comes into play in these kind of sentencing regimes, like you talked about min-mans, because I think we have something very good in Florida, which I will cover in my criminal procedure class, and it's called a criminal punishment code score sheet. And what that is it's a conglomeration of your prior record, the severity of the offense, all sorts of things, what the injuries were caused. It's all put into a nice sheet, and then you score up, and then it gives you a minimum mandatory sentencing range, right? And I find it to be very fair. It's a good independent measure of what should be the sentence in a particular case. So I would advocate that a judge should always sentence the score sheet unless they go above or below, which they need to write in order to depart from that. The problem is so we got this great score sheet and everybody goes, yay, good score sheet. And then somebody gets killed and they say, well, we need to have Justice for Cayley Act, and we need to have the Justice for Brittany Act. And, we need to have the 1020 life. We need to do something about it. The politicians keep adding and adding and adding to these different, and it just goes towards more and more and more severity. And it just becomes out of control and complex. I mean, Florida sentencing law is so complex because of that add-on effect. If we just went with a score sheet and agreed with that and stopped messing with it, but politicians can't do that. They got to keep adding. And nobody's saying we need to be lighter on crime, at least not in Florida.
I got some Rumble rants that came in, it appears. Rivka, the Jade Gamer. Under the current model, every defense attorney is guilty of conspiracy to obstruct justice because they exist to prevent a guilty verdict.
Right. And look what they're doing with Trump's lawyers, right? They're charging the lawyers because they had an opinion advising him on what to do about an election. So there is something called election law. And if you're a lawyer practicing election law and you say, hey, we need to follow these processes, now all of a sudden you're trying to overturn an election, inspiring to overturn an election. Again, it's, we're criminalizing the practice of law.
Which is very interesting. Somebody brought that up because what does this do? Well, it essentially just puts all the power right into the parties who are going to make the determination, however they do, and no lawyer is going to want to volunteer to defend anybody because they'll wind up getting prosecuted too. Rivka also stated, when I'm president, I'm going to appoint a defense attorney as my AG. Okay, well, see how that goes.
But defense lawyers aren't necessarily better. I mean, it takes a matter of fairness. I've seen one of the worst judges I've ever been in front of, bar none, was a former public defender, Judge Wolf in Putnam County, not to name names. But I mean, he was terrible. And he used to always say, just before you get ready to screw your client, I used to be a public defender. I don't know. I don't. It's sort of a cultural rot problem more than it is. I mean, it's just in fairness to the prosecutors out there who may be yelling at me.
True. And Torin 3, Rumble Rant. Did you catch the ATF lawyer ducking the judge's question how the ATF can say 8 hours of highly skilled work repairing a Tommy gun with metal poured down the barrel is readily converted, but a few minutes and a few dollars by someone with the non-expert skills to convert an AR to fully auto isn't readily converted? I don't know the case, but interesting question. I'm not sure. Maybe they're also working on the Alec Baldwin gun.
Just fill it full of concrete or whatever.
All right, so let's jump forward. Ian, you've been covering Liberty Safe. I am completely clueless. I see little headlines like the Quarterly and other people. They're talking about Liberty Safe. Babylon B says that it only turns to the left to unlock. I don't know.
So what happens here, and there's a political aspect, but the political aspect is probably a red herring because Liberty Safe is probably doing this to everybody. But the political aspect is that this comes around with one of the January 6th defendants, and the FBI got a warrant to search that person's property. And so with that warrant, they went and they encounter a gun safe. So what do? They contact the safe manufacturer, Liberty Safes, and they say, we have a gun safe. How do we get into it? And Liberty Safe says, we want to see the warrant, but the warrant just says, listen, we have a right, we're entitled to search this property. It's not a subpoena that compels Liberty Safe to act in any way. So Liberty Safe would have been 100% in their rights to say, go to hell. That, this is a safe. It's a you problem. You guys have, and I mean, the FBI is going to get into the safe, right? 100% they're going to. Those safes are rated for, with tools, maybe 15 minutes, which means somebody with an angle grinder can just saw the front off it and that'll happen. But you want to make them do it. You don't want to you don't want them to just be able to bypass it, because if they can bypass it, then they can do things like enter covertly. And they can also potentially say, oh, this person consented to the search, because and it'll be like, how did we get into it if this person didn't agree to the search? So any problems with our warrant are now meaningless because they agreed to the search. I want them to cut open my gun safe. I might have spent $7,000 on a gun safe. If the police are there, I want them cutting it open, because that $7,000 is going to save me $14,000 in legal fees. But Liberty Safe doesn't actually do this. They don't say we need a subpoena, anything. They're just like, okay, sure. And they provide a code that allows for the safe to be unlocked. And so they go and they have a look in it. Now, people were justifiably pissed, because when you buy a safe, it literally is for one function, which is to keep your things safe. It's in the name.
It's right there in the title.
And Liberty Safe especially pissed people off because they have been touting themselves as the company of liberty. And yet the instant there's a taste of boot, they're just instantly like, let's flip on this. So
somebody sent this too. They have a donation pattern. It appears that they severely favor one party over the other, like to 100%.
But the thing is, it's not just Liberty Safe that builds these back doors in. Just about everybody, like all of these companies do. And the reason why is because people forget their codes and they get really pissed off if they call the safe company and they're like, how do I get into it? And there's like, destructive entry. That's how you do it. That really upsets people. So they build these back doors in. And the way these back doors work is usually there's one of two sorts of methods, which is that there's always like a second code that you don't know about. And that's either they generate them randomly, but they build a table of this serial number matches to this code, or they have like a master code that the serial number is used as a salt for. So that serial number then modifies the master code to get you what will work on your safe. But either way, it's a combination of this, secret information plus your serial number gets them in. Liberty Safe has now said that they will. So I don't know if we can bring it up. Liberty Safe made a statement, and it was some of the most amazing weasel wording. Like, I really want to give this guy props, not because he's like somebody I like, but just because they did their job well at weasel wording. They basically they're like, we don't do this without a valid warrant. And they're trying to convince the public that means that they're compelled to do it. And lots of news sites bought into this. There were sites like MAGA upset at Liberty Safe for complying with valid warrant. It's like, you're not complying with it any more than I am. because the warrant doesn't affect them at all. They're not complying or rejecting it. It's just they're using it to make their decision, but they're not compelled by it. But they want to imply that, right? They tried really hard to imply, listen, we had no choice. They had a warrant, which is not true. Like, they had every choice in the world. And then they backpedaled from that and they said, oh, well, we'll give you the ability now. They've said, now going forward, we're not going to do this unless we've got a subpoena compelling us. But also we'll give you the right to, you can send us a message and we'll delete the information we have about you. And I'm going, that's great if I trust you. And I don't, like, at all. So how do I know you're deleting it? Well, trust us. Oh, you mean trust you when you did this stuff before? But people want to boycott Liberty Safe. And I can get why for the cooperation. But they're saying, oh, I'll buy a different safe. And I'm going,
But are they doing it too?
Well, often it'll be like a different company's made the safe. But the problem is the lock set is made by the same company, because there's not that many companies that are making these lock sets. So it'll have the same feature. And that also means that there's actually another point of failure, because it may be that the lock set manufacturer may not does, but may also know the how to get into it. So
this chat brought up something that made me think of immediately. Apple was a good precedent with this, with the San Bernardino shooters. I don't know if you recall, Apple told the FBI to pound sand.
Yeah.
Because the FBI said, hey, we want a back door into your phones. And I don't know if Apple's still holding strong. As far as I know, they are, not necessarily because they're that concerned. It's a competitive advantage. I mean, obviously Google makes their money by giving the information to everybody on the planet, whereas Apple, the customer is who's paying them, and that's why they aren't doing it. But it was a good precedent.
There's also a real advantage that safe manufacturers have on fighting this, which is that, let's say the FBI does get a subpoena to compel the production of this information. Well, what would I do if I'm Liberty Safe? I'd be like, let's fire up my lawyer. Well, hey, get out of bed. I need you to contest this subpoena. And you could tie it up for a week. Let's say they get it into court real fast and it's in a week. Well, what's the FBI doing in that week? They're busting out the angle grinder. And then you just say, well, it's moot because they already angle grindered their way through. And that advantage of just being able to stall things out to make it more of a pain because they do it like the FBI does it because it's easy. And if it was cheaper and easier to bring a locksmith out than it is to do the subpoena, they're going to go locksmith every time. And that's what actually standing up for yourself and showing some backbone would force the FBI to do, is they'd have to get the locksmiths. So whereas Apple, like, they're not getting into that phone without without breaking through the encryption, which is probably not going to happen. So
it's a challenge. Well, okay, so somebody jump in on this, because this goes into what you can break or not break, and then forcing somebody to give up something in their mind versus something from their body. Does anybody want to get into that whole thing? Because I'm curious your thoughts on that, where, like, if they hold up a thumbprint and it does the phone, that's not considered intrusive, but if you tell them to give you the passcode or safe combo, I feel like there's a parallel with a phone and a safe. I'm not sure, but it would seem that way.
Well, it's an additional, or sorry, go ahead. I've been ranting about this.
I was going to say, one thing can be testimonial versus another, but to Ian's point, to make sure people are catching it, because I was watching the chat while he's talking about it. So if the police come to my house right now and say, we have a warrant to search your house, right? And it's valid and all that, I can't impede that, right? So I just have to sit here and watch it. Well, that warrant doesn't mean that they can call the people that built the house 20 years ago to come tear down a wall to see what's bad. Like, it's not obliging anybody else. The warrant is for me and my property here. Now, if the police need something from here or from another location, another entity, they can subpoena that person potentially, which is what Ian said. So you could subpoena Liberty Safe and say, hey, we need this combination, because the warrant for the home of the guy, that doesn't have any legal effect on Liberty Safe. Why would it? And then Liberty Safe could comply with the subpoena or contest it, as Ian said. So they have no risk to not complying with a warrant that's addressed to somebody else any more than anybody else would. The only risk would come in the subpoena, and then only then, of course, if they decide to contest it and it's still found lawful or whatever. So that's why Liberty, I think, I supported the hot water they were in. It was like, you guys aren't even requiring a subpoena for this information. You're just like, oh yeah, okay, well, here's the code, because you have a warrant for this guy. Here's the code. But if I bought the safe and lost the code and call, hey, can you tell me how to get in my own safe? They're like, oh no, you gotta hire a locksmith, bro. So they treated their customers worse. And it's not like they just gave anybody who had a lawful right to the code the information. They gave only the police that, and not even the owners of the damn safe. So if I had a Liberty Safe and I lost the code, I might call a police friend and say, could you get a search warrant for my safe? And then Liberty would give him the code and I could get into it without having to pay a locksmith.
Just, call the police and say, hey, I can't get into my safe, but it actually has like a kilo of heroin in it. Can you?
Right.
And when the police come and they're like, oh, you said there was heroin in here. Oh, I must have already done all the heroin. Thanks for getting me into my safe, though.
Yeah.
This is not legal advice. This is humor, folks.
No, this
the
is far
police
away
would
from
find
legal advice.
something. They would find something to charge you with. They'd make it up if they had to.
All right, let's go.
You're not even.
Oh, sorry.
Well, the other thing is, even as the homeowner, you're not typically required to provide a safe code. Like,
Yeah. Right.
if the police are searching my house, I can't go and like try to start hiding things or like throwing locks to like make it harder once they've got here. But when they come and they say, hey, you've got a safe, it's like, yeah. And they're like, so what's the code? The code is go to hell, because I'm not required to help you out.
I'm trying to think about, I was looking around for this because we're actually dealing with this right now in our office regarding disclosure of cell phone codes, passcodes, right? Encryption keys. And the state attorney's office has subpoenaed or basically done a motion to compel against our client to give up the passcode to their phone. And I forget, I was working on this issue. It was our trial division, and I'm not sure the result in that. But, people think, oh, I don't have a safe, I don't care. But you have a phone. And what if, and this, they want to get evidence. They think there's evidence of a crime that's on your phone, and we want you to disclose us the passcode. My response to that is, I remembered it, but my memory sucks and I've forgotten it. So I don't.
There's the other problem too, where with the phone, I mean, all your life is in there. Medical things. I mean,
they're
there's a lot of info.
going for specifics. They're not going to search the whole
Well, that's
thing.
my point too. So it's like, oh, you know what? While we're here,
trust me on this.
While we're here, let's just and how many things have spun out of over broad searches.
But there's also like two separate bits of evidence there. Like, let's say you've got a gun safe and it contains some incriminating evidence. Well, they'll get to that evidence by cutting through it. But there's the further evidence of you being able to provide the code, and that provides evidence that you were in possession of whatever's in the gun safe. And it's fundamentally testimonial in nature. It's, you've got a right to silence. That's violating that right to silence in a way that is highly incriminatory. Now, I know in court cases they try to get around that by saying, well, we already know what the contents are, and we're not going to use this person presenting the password as evidence. Do you think they're going to accidentally let that slip in front of the jury? Like 150% they will. But oh, sorry, that's just for the narrative. Jury, you're cautioned not to rely on this for any other purpose other than, yeah, that's not going to work. It's so damaging in that sense. And there's a very real risk that you're going to end up with somebody who gets convicted based on actually forgetting things. The number of people I know who've had safes who've forgotten the combo, and they call a locksmith, and the locksmith's like, yeah, I'll get you in. It's going to be $1,000. And they go, I don't care that much. Like, it's just a big, sure, I can't put anything in that. I'll just use it as a shelf. And then the police come by and they're like, you have to provide this safe code. And the person, how do you prove you don't know a safe code? How do you prove you've forgotten the password to your phone?
I've gotten locked out of my emails for a month because I can't remember my passcode. And so I keep putting it in and then it blocks me because it says, you've tried too many times. That's happened to me twice.
I mean, I set passwords for things that are like 30 plus characters long. And
I hate that they send you this thing that says, oh, you need to reset your password and you can't use one that you've used before.
Oh, that's the worst.
Oh. Yeah, it's like I was just using a really convenient one. Can I use it again? No.
If my password is like, 100 characters of random gibberish that I've managed to memorize, how long do you think I'm going to be able to memorize that if I'm not typing it in on the regular? Not long. And so, the police come, they seize your stuff, they keep it for like 4 months while they do the investigation, and then they come back and say, what's the password? And you're like, I could have answered this question 4 months ago, but I can't answer it today. And they're like, well, we'll put you in jail until you manage to remember this like random code. You're going to be in jail for the rest of your life.
They're talking about thumbprinting it, but what if they order you to use your thumb, put your thumb on the thing? Is that speech?
On a reset, that won't work either.
Yeah, and see what Steve's talking about. I was thinking about this while Ian was talking to. This is, for example, if you're in a lineup with people, that's not testimonial. They can make you stand there being in a lineup, and in some jurisdictions, they can cause you to give a voice exemplar, and they say that's not testimonial, right? So the question, but if they want your DNA or thumbprint to identify you, that's also not testimonial, generally speaking. So, as Ian said, if you have a right not to testify against yourself or incriminate yourself by giving this passcode, then it goes to Steve's point. What about if they say, well, that's fine, but your thumbprint is not testimony. It's just a natural thing, and we're going to order you to stick your thumb on there. You'll be is that a valid order? So, Steve, what do you think?
Right. Well, what happens all the time is for the prosecutors to order our defendants to, say, display a tattoo. In fact, I was a prosecutor. I had that. We had one of my most interesting cases. It was actually on World's Dumbest Criminals involving I was the prosecutor, and it was a guy who was a mob hitman for the Bonomo crime family, Joey Calco, who was also known as Joey Milano in Flagler County, Florida. It was the Goomba's Pizzeria case. And I had to prove this guy was in the witness protection program as a 3-time mob hitman, 3-time murderer. And he had moved to Flagler, and he got into a scuffle with somebody, and the feds would not cooperate with my identification because I had to show he was a prior convicted felony. He had 3 prior murders, right? But the feds wouldn't cooperate. So I had to show that he was the same guy on this conviction because they changed his name in the witness protection program. And one of those ways was by identifying tattoos. So as a prosecutor, I moved the court to have him inspected, photographed with his shirt off, showing his tattoos that matched up with the judgment and sentence on the prior conviction. So that happens all the time. They'll have people stand up in front of the jury, show the jury your tattoo on your neck that says guilty, right?
I killed him. Yeah.
Yeah, poor choices.
Well, speaking of guilty, it's like we're 2:30 a.m. here, Korea time.
Yeah, we're wrapping up right now. Anyway,
right.
This has been a phenomenal discussion. I appreciate just going and just talking out theory, different things like that. I feel like I learn a lot from this, and I hope everyone else does too. And if you like this kind of thing, consider subscribing. You could find everybody. Steve Gosney, I think, has a web address.
Oh, is that a cue? SteveGosney.com. Yeah. So go to SteveGosney.com for all things Steve Gosney. That includes my books, which you should buy all of my books. I know there's a lot of people that watch me and enjoy my content. Some of them even have one of my books, but I've got 4 books. So if you don't have them all, you need to have them all because they're all worthwhile.
I have them all.
I have one, I think. Ian.
You can find me at Runkle of the Bailey on YouTube. If you're interested in geek content, I also have Roll of Law on YouTube, but that's more niche and less commonly updated. I talk about firearm issues, Canadian legal issues, all sorts of random stuff. I've been covering the Murdaugh because that is wild. I really want to see the response to that. I'll be covering that the instant it drops, because there's one of two strategies I see. They either say, yeah, we need an evidentiary hearing, or they just start fighting. And I don't know which it's going to be, but I'm excited. So check out the channel. I'll have updates on that. So,
Chandler, what do you have coming up? I hear you're celebrating something today.
Oh yeah, actually, I had moved the celebration back and forth. I have just become monetized, and a lot of that is thanks to you, Eric, and thanks to everybody on panel. You invited me here, and I think that was when I broke my 1,000 subscribers. That was a big part of it. Tomorrow at 7 p.m. Eastern Standard Time, I'm having a monetization celebration stream, and you're all welcome to come if you would like. I can send everybody the link, and I'm very excited about that. Later today, I'm going to be doing my regular feminism stream, same time, 7 p.m. Eastern Standard, and that's just talking about how feminism is a scourge upon society, and how we need to talk about sexism against men. So that's going to be great, and I'm looking forward to that. But yeah, celebration tomorrow. Everybody's welcome.
Awesome. And Steve Gosney looks like he's about to get blown away or something. Legal Vices. Where can we find you?
Hey, right there, Legal Vices. That's me. I don't have a billion different channels with a billion different books. I just have my winning and charming personality to offer in exchange for your super chats, etc. Legal Vices. That's me. Right now, these days, we're doing we're doing as much follow up as we can with this Murdoch trial thing as this whole thing plays out. I guess we can expect to see the state's response to the motion around Friday of next week. In the meantime, we're going to be talking a few things about that. We're doing the dramatic readings with Chandler Remington, Hayden Ozzy Overlord, and Megan Fox. Dramatic readings of the Depp v. Heard sidebars. We're doing all of those day by day until we run out of days. That's what we're doing there.
All right, and the ever verbose Steve of Southern Law.
Well, I do want to say before I push my channel that if you get all 4 Steve Gosney's books and assemble them in the right order, it will reveal the password to his email. So earlier today, I did stream Sarah Boone's hearing with the judge, where she was told she wasn't at Burger King, and before that, a lot of detailed documents, case law, and stuff on the Murdaugh case, and also what's happening in Coburger, where the state and the defense team up to say there should be no cameras in the courtroom. That's what was today.
All right. Well, fantastic, folks. I have a show, Americans Untold Stories, Freeform Friday, later today. And if you like this kind of show, though, you like these panels, every Friday at noon Eastern, consider coming by. If you really like it, subscribing would always be cool. Thank you so much, and I'll see you next week.